Okay, good morning. Welcome, everyone. And thank you for joining today's Danos Group and Norton Rose Fulbright webinar on the UK Employment Rights Act 2025, key reforms and market impact, and what this means for financial services leaders in 2026. My name is James Franklin. I'm Managing Director and Head of Legal at the Danos Group, one of the leading governance, recruitment and consulting firms, and I'll be hosting today's session. We're really delighted to see such a strong attendance from across HR, legal, compliance and wider financial services. Today's session is designed to be practical and commercially focused. UK Employment Rights Act represents one of the most significant shifts in employment law in recent years, and many of these reforms have begun taking effect already and later this year. But just before we begin, just a few housekeeping points. Please could you remain on mute throughout the session just to minimise background noise. Questions can be submitted at any time using Teams Q&A or chat function, and we will leave some time for audience questions at the end of the discussion. So we're very pleased to be joined by two leading employment law partners from Norton Rose Fulbright. First, Paul Griffin, EMEA Head of Employment at Norton Rose, who advises major financial services institutions and global organisations on various complex employment law investigations and governance matters. And alongside Paul, we're joined by Jonathan Newman, who is also a partner and employment lawyer at Norton Rose Fulbright, specialising in disputes, litigation strategy and senior executive matters. Thank you, Paul and Jonathan, for joining us today. And Paul, I'll hand over to you to begin.
Thanks, James. So today we're going to give you a summary of the Employment Rights Act 2025, and in particular focusing on those matters which have come into force this year. The ERA is, as I'm sure you're all aware now, one of the most significant pieces of employment legislation for a generation. As well as looking at the details of the provisions in the Act, we'll look at what steps employers should be taking to prepare for those changes. Next slide, the implementation timetable, please, Sarah. So before we look at the details of the provisions, we thought it would be helpful to provide you with a timeline for when the changes are coming into force. The government published a roadmap before the Act came into force, and this is pretty much the same timeline with some minor amendments made at the beginning of this year. You'll see from the timeline that in most cases the changes will become effective in either April or October of the relevant year, and aligning with the current practice around when most changes to employment legislation tend to take effect. There are a couple of changes coming into force on the 1st of January next year, and those are the really important changes relating to unfair dismissal and fire and rehire. And these provisions will require steps by employers this year, and we'll look at those with you today. So next slide, please, Sarah. As promised, we're now going to have a deeper dive into some of the changes which have already come into force in April this year. And the first change, which has been given quite a bit of press coverage, is the change which makes statutory sick pay payable from day one of sickness rather than day 4. Also, the lower earnings limit has been removed, meaning that all eligible employees, regardless of earnings, are now entitled to SSP, and so extending the eligibility to SSP to a wider group of employees effectively. Those earning less than the lower earnings limit, they're entitled to SSP at the rate of 80% of their weekly earnings. As employers, you should have taken steps now to ensure your contracts of employment and relevant policies are updated and remove references to waiting days and references to the lower earnings limit. And you should also have checked that your payroll has been amended to take account of these changes. And another point which employers may not have considered is reviewing your short-term sickness policy. If SSP is payable from day one, there has been a suggestion that there may be an increase in repetitive absences by employees. So, for example, more people entering what is fondly termed sometimes the Monday Club. If that's the case, you must make sure that your line managers are trained to deal with sickness absence and identifying when people are absent and ensuring they monitor any consistent short-term absences. So the next area on the slide that changed in April is the change to the maximum protective award for failing to comply with collective consultation obligations. And that doubled from 90 to 180 days per employee. The duty to collectively consult is triggered when an employer is proposing to make 20 or more employees redundant at one establishment and within a period of 90 days. And if the employer fails to carry out those information and consultation obligations correctly, then an employment tribunal can now make an award, which is up to 180 days uncapped pay per employee. As tribunals do tend to start with the maximum, the consequence of breaching the obligation to consult is more severe now we've got these changes. So employers must exercise particular caution with collective redundancy consultation exercises to ensure they're not liable to pay the higher amounts. And it's worth bearing in mind that you can't contract out of the protective award claim we're discussing, even by way of a statutory settlement agreement. A solution to that has been to specifically say in the settlement agreement that the protective award is being paid, so earmarking a sum for that so that no more compensation is payable, even if a claim is made. But the price tag for that has now gone up substantially, especially if you're dealing with senior employees who might not expect to be involved in collective consultation, but nevertheless are also protected. We should also mention here that the government intends to amend the threshold for when collective consultation is required. Collective consultation will be required still where the employer proposes 20 or more redundancies within a 90-day period and at one establishment. But there'll be a new threshold which will be determined without the one establishment requirement. And the method of calculating this new threshold is yet to be finalised, and the government has issued consultation on how this should be determined. It does mean that employers will need to stay on top of all redundancies being proposed within a 90-day period across the whole business. And also, this isn't expected to come into force until 2027. But it's worth employers considering this year what processes they'll put in place on top of these calculations across the business. So finally, on this slide, we've mentioned the changes to paternity leave and unpaid parental leave, which came into force on the 6th of April. And these two rights are now day one rights. Also, there's been a change as to how paternity leave can be taken with shared parental leave. Before, you could only take paternity leave before any period of shared parental leave, and now that requirement has been abolished. This will mean that you should have updated your relevant family policies and your staff handbooks and the intranet guidance and all your onboarding documents to reflect these changes. And also to mention here that there's a new right of paternity leave for bereaved partners. This isn't actually included in the Employment Rights Act, but new regulations provide that the partner of a mother or primary caregiver who's died can now claim statutory leave of up to 52 weeks from the day the mother, the primary caregiver, dies until 1 year after the childbirth. It's currently unpaid leave, and so if entitled, it's actually more likely employees will exercise their right to parental leave. However, you should be aware of this right and also have in place some form of policy and procedure to cover if an employee wants to take it. Next slide, please, Sarah. So moving on to some other changes that took place in April. The first one on this slide is that disclosing sexual harassment has now been added to the list of matters capable of constituting a qualifying disclosure for whistleblowing purposes. Although raising allegations of sexual harassment could be a qualifying disclosure when framed as a breach of a legal obligation or criminal law, this inclusion now has made it more certain, which is good. All the other provisions, though, of Section 43B that relating to qualifying disclosures remain the same, including that a worker must reasonably believe that this disclosure is made in the public interest. You'll need to check then that any whistleblowing policies and procedures are up to date to include this as a qualifying disclosure. The next point on the slide is the requirement to keep records relating to holiday leave and pay. And this was always included in the ERA, but it wasn't included in the implementation timetable. It wasn't until mid-March, when the second set of implementing regulations came into effect, that we knew it would apply from April. So what it means is that there's a new duty on employers to create and retain records that are adequate to show that they comply with statutory holiday rules. So this covers having records that show that the employer has complied with the requirements relating to the amount of statutory leave taken by each worker and the calculation of leave for irregular hours workers, and also the calculation of holiday pay and including the amount of pay which the employee is entitled to on termination. Employers have to retain those records for at least 6 years, and they may use any reasonable method or format to create and store them. But failure to comply with this duty can actually be regarded as a criminal offence, and it's punishable by a fine. As a result, you really need to evaluate whether your existing record system is sufficient or whether new and accurate procedures and retention policies for holiday leave and pay need to be implemented. There are a few changes which took effect in April 2026 relating to the recognition of trade unions. The trade union recognition process is very complex, and part of the process for change is to simplify this process. And the Act simplifies this recognition procedure, effectively making it easier for unions to become recognised. Finally, here, we set out that the Fair Work Agency has been established. This agency is going to take over the existing powers of the Employment Agency Standards Inspectorate, HMRC's National Minimum Wage Enforcement Team, and the Gang Masters and Labour Abuse Authority. And it'll also have new powers relating to holiday pay compliance and sick pay. And the agency will have the ability to bring tribunal proceedings on behalf of workers and provide them with legal assistance and to reclaim enforcement costs from non-compliant employers. And it's not clear, though, when these powers will come into force, but we'll let you know. You should be now auditing your practices to ensure that the compliance with the national minimum wage and holiday pay, for example. Okay, next slide, please, Sarah. So I wanted to move on to the changes that are due to come into force in October this year so that you can prepare for those. The first change mentioned on the slide is the change to anti-harassment provisions. So from October, it'll become a requirement on employers to take all reasonable steps to prevent sexual harassment of their employees. And this is a higher standard than the current requirement of merely taking reasonable steps. But if you've already been conducting your risk assessment and taking steps since the obligation was introduced, it'll hopefully not have too much of an impact on you. In addition to this, will be the requirement on employers not to permit the harassment of their employees by third parties. This means there'll be a standalone claim that workers can bring against their employers if they've been harassed by a third party in the course of their employment, and the employers failed to take all reasonable steps to prevent the third party harassment. This will cover the types of harassment against an employee based on protected characteristic. And if it isn't clear what steps will be considered to be reasonable for the employer to take, but the government has indicated that the steps in respect of the actions of third parties will be more limited than the steps an employer should take in respect of its own employees. So before October, you should be reviewing your policies and contracts, including your commercial agreements with third parties, and ensuring that everyone's aware of how to comply with the new duty. And you should also ensure that your training includes specific points on preventing sexual harassment and what employees should do where issues arise with third parties, and ensuring you have robust reporting and investigation processes in place. There are some additional trade union changes coming in October this year. First, there's the new duty for employers to inform workers of their right to join a trade union as part of their required particulars given by the employer. The consultation was issued on this at the end of the year, and this consultation looked at how the information should be given, and we'll have to wait for those final proposals. Also, the ERA will strengthen a trade union's right of access, and this will allow trade unions right of access actually both to the physical and digital workplace. And access isn't to be permitted for the purposes of organising industrial action, though. Secondary legislation will have to be published, setting out various elements in detail, including the operational and practical details in relation to requesting and negotiating an access agreement, the Central Arbitration Committee's determination on whether access should take place, and the CAC will make decisions on the level of fines, for example, for breaches of access agreements. And this all applies to unions that are not even necessarily recognised. The government has launched a new consultation introducing a draft statutory code of practice, which will set out practical guidance on how the right of access should operate in practice, and also provide standardized templates. And finally, there are changes for rights and protections for trade union reps, including the provision of reasonable facilities and accommodations for them to carry out their duties, and extending their protection against detriments for taking industrial action. I'd say in light of these changes, you need to consider how you'll inform workers of their right to join a trade union as part of their onboarding process, and where and how such information will be published internally, and whether changes are needed to your offer letters, for example. Finally, before we move on, we've mentioned the extension of tribunal limits. They'll be extended from 3 months to 6 months, and this will apply for all types of claims apart from breach of contract claims, which will remain at 3 months. Next slide, please, Sarah. There are a couple more changes coming in October this year, which I'll just mention briefly. For those of you in the hospitality and leisure sectors, October 2026 will see the tightening up of tipping law, and under the new Act, employers will be required to consult with representatives or even workers directly when developing or reviewing their tipping policies, and these will need to be reviewed every 3 years. A consultation paper on this was published to gather views on both the new requirements and also on the statutory code of practice and the non-statutory guidance. We've also just mentioned on here that the fair pay agreement for the adult social care sector will come into force in October as well. And I'm handing over to Jonathan now to look at unfair dismissal, I think.
Thank you, Paul, and good morning, everybody. Sarah, next slide, please. So I think, Sarah, that's the slide. Paul has walked us this morning then through the changes set for 2026. I'm now going to horizon scan into 2027, starting with a couple of very significant changes due to be implemented on New Year's Day. Whilst they don't come into play for another 7.5 months or so, they change the unfair dismissal landscape considerably. So they're matters which you ought to be considering this year prior to the changes taking effect on the 1st of January. Now, you may recall that the government's original proposal in the Employment Rights Bill was that unfair dismissal would become a day one right. This caused a great deal of concern about the impact on recruitment, so following roundtable discussions with business leaders and trade unions, the government made a concession. What they agreed was that the qualifying period for unfair dismissal claims will be reduced from the current 2-year period to 6 months. This means that anyone whom you employ from the 1st of July this year will have protection from unfair dismissal by the new shorter qualifying period coming into force on the 1st of January. The main impact of this for you as employers is that decisions regarding retention of new staff ought to be made within the first 6 months of employment in order to mitigate potential liabilities for unfair dismissal. This means employers will need to carefully and effectively manage both recruitment and probationary periods going forward. Now, we are being asked a lot by clients about probationary periods at the moment. That's because if you have a 6-month probationary period in your contract, which is fairly common, then for joiners after the 1st of July, waiting until the end of the probation period to determine whether you're going to dismiss will mean that the employee acquires 6 months service and is entitled to bring a claim for unfair dismissal. Also, even if you decide to pull the trigger a few days before the end of the probation period and pay the employee in lieu of any contractual notice period, you're still required to add the minimum statutory period of 1 week when determining the effective date of termination. The upshot of all of this is that you may want to reduce your probationary periods for new joiners to say 3 or 4 months in order that you can take a considered view on whether to continue their employment without the risk of an unfair dismissal claim. Now, the importance of this, I don't think, can be overstated, because as you may well have seen in the press, seemingly out of the blue, the government also removed the statutory cap on unfair dismissal compensation. In other words, the current cap, which is the lower of approximately £123,000 or 1 year's pay, will no longer apply to unfair dismissal claims. I think this amendment is consequential and far-reaching, and no doubt will be of concern to those listening. On the one hand, we have, of course, got fairly used to seeing perhaps tenuous claims for discrimination or whistleblowing as a tactic to circumvent the current statutory cap. So it might mean we've seen fewer of these claims upon termination. Personally, I'm not convinced by that, as claimants are still likely to kitchen sink it, if only for the reputational leverage. However, where it will have more of an impact is on the actual decision to dismiss employees or not, and the manner in which to do it. For example, in cases of underperforming directors or senior executives, it's often not in the interests of either party to undertake a protracted performance improvement process. The standard playbook has typically been that such employees are exited promptly, despite the unfair dismissal risk, and the employee usually reaches a settlement as they know their compensation would be capped if they went to a tribunal. However, with no compensation cap from the 1st of January onwards, there'll be a much higher financial risk for employers in dismissing an employee without following a fair procedure and without a fair reason. Depending on the circumstances, the executive might well be able to claim loss of earnings and potentially lucrative benefits at a significantly higher rate than the current cap of 123,000, and possibly for longer than the current limit of 12 months. Now, just a couple of flags to close out this point. Where a tribunal makes an award of compensation, you'll probably be familiar that there are certain percentage deductions which can be made. These include deductions due to contributory fault, so that means where the employee's own conduct has contributed to his or her dismissal in some manner, and also applying what is called polky, meaning that compensation can be reduced by a certain percentage to reflect the chance that the employee would have been dismissed in any event, and that the employer's procedural errors essentially made no difference to the final outcome. Currently, in my experience, employers rarely give consideration to polky reductions until much further down the line. And the same applies for mitigation evidence as well. And by that, I mean evidence of suitable alternative employment that the ex-employee could take moving forwards. However, considering the uncapped nature of claims from January the 1st onwards, I think it's going to be important to collect evidence of contributory conduct and whether dismissal would have occurred in any event from before the point of dismissal. And that's to give you a better argument for compensatory deductions. Not only will this help if the matter ever litigates, but perhaps more pragmatically, it would also go a long way to securing settlements at reasonable levels as well. Next slide, please, Sarah. Now, there is another very significant change coming into force on the 1st of January, which is the change to the fire and rehire regime. Fire and rehire, as you may know, refers to the practice of dismissing and then re-engaging employees in order to force through changes to their terms and conditions. It's currently considered a potentially fair reason for dismissal under the limb of some other substantial reason. Although currently it should only be used as a last resort, and there is a code of practice which urges consultation prior to making any such changes. The Employment Rights Act is going to introduce a new provision, making it automatically unfair to dismiss an employee who refuses to agree to a so-called restricted variation, or to replace an employee with someone else on those varied terms. Now, a restricted variation is a new legal term, and it's limited to the core contractual terms listed in the Act itself. These are reductions in pay, changes to pension entitlements, amendments to working time, changes to shift time and duration, and also the inclusion of a new flexibility clause into the employment contract. The intention behind the legislation is essentially to crack down on unscrupulous employers seeking to exploit workers. The reality, though, I think is far broader, as it essentially curtails the ability of an employer to make changes to pay or pension entitlements and so forth, where the employee doesn't agree to those changes or where there is no pre-existing contractual flexibility. This means post-acquisition harmonization, or cost reduction programs, and even restructuring projects could all potentially fall within scope. Now, to be clear, fire and rehire of an employee for refusing to agree other non-restricted variations will not be considered automatically unfair under the new regime. However, it may still be potentially unfair under general principles. And going forward, tribunals will be asked to imply enhanced fairness standards. And by that, I mean considering both the ordinary unfair dismissal principles and additional statutory factors as well. And that includes the reason for the variation, whether an incentive was offered to the employees to secure agreement, and also the quality of any employee consultation. For completeness, there is a limited defense to the new fire and rehire regime, which is where the business is in extreme financial distress with no viable alternatives. In those circumstances, any dismissal would not be considered automatically unfair. However, in order to pass the financial distress defense, the tribunal would interrogate various factors in evidence, especially the financial affairs of the employer and the likely pipeline of work, which of course are not matters any employer would typically want to put before a public hearing. The government has emphasised that the new regime will only apply to changes made through fire and rehire, and I think that's an important point. Employers will still be able to make contractual changes, even for so-called restricted variations, via other lawful means. Now, this means changes can still be made via consent, normally following consultation and usually with an incentive to agree that change, or by using existing contractual flexibility clauses to the extent those clauses are exercised narrowly and reasonably. Now, with such an important change on the horizon, what practical steps can you take? Well, I think now is the time really to consider introducing flexibility provisions within your contracts for new hires or even current employees. That's because introducing a variation clause after the 1st of January that covers restricted variations could itself amount to an unlawful restricted variation and trigger an automatically unfair dismissal. These clauses will be very difficult to change once these provisions take effect, so it is worth doing it now in your template employment contracts. However, again, just a note of caution, unilateral variation clauses are not a silver bullet. They don't give an employer carte blanche, and a tribunal will generally interpret them narrowly and in favour of the employee. Next slide, please, Sarah. 2027 is also going to herald new obligations in relation to equality. The first is the requirement on employers with 250 or more employees to develop and publish equality action plans, and that's going to be on an annual basis. These plans must detail measures being implemented to address the gender pay gap, and also measures to support employees experiencing menopause. The reporting obligations will take effect next year in 2027, meaning that the first mandatory action plan for the 27-28 year will need to be submitted alongside the gender pay gap the following year in 2028. Prior to that, the government is encouraging employers to publish action plans voluntarily for the 26-27 year, and in fact, even smaller employees who are not required to publish a plan are also invited to consider preparing and releasing one. Now, to assist with compliance, the government has published guidance for employers, together with a list of 18 recommended actions for consideration. At some point soon, your organizations will need to start gathering statistics, considering appropriate changes to pay, and developing your action plans prior to the introduction of the reporting obligations next year. Now, the bottom half of this slide refers to the incoming ethnicity pay gap and disability pay gap reporting obligations as well. This is not actually within the Employment Rights Act, but it's contained in the draft Equality, Race and Disability Bill, and we thought it's worth flagging at the same time. The government published a response to consultation in March this year, and it confirmed its intention to align with the existing gender pay gap framework. What this means is that the new reporting regime will be mandatory for large employers with 250 or more employees. And the scope is expected largely to mirror the gender pay gap regime as well, meaning that employers will be required to publish the same calculations currently used for gender pay gap reporting. In addition, the new regime will require employers to publish workforce composition data as a meaningful context, including regional demographics and also labour market factors that may influence diversity and may also affect pay outcomes. Declaration rates for ethnicity and disability will also have to be published, which means that employers will have to be expected to rely on self-reporting. And just digging a little deeper into that, for ethnicity, employers will be expected to collect information aggregated into 5 broad ethnic groups, and there'll be a mandatory binary comparison between white employees and all other groups combined. Disability pay gap reporting will also adopt a binary comparison between disabled and non-disabled employees, this being based on the definition of disability in the Equality Act. Minimum reporting thresholds will be applied to protect confidentiality, which means that there'll have to be a minimum of 10 employees in each group before a comparison can be reported. Now, we're expecting further regulations before these obligations take effect, and the timing of the first reporting deadline isn't known yet. It is anticipated to be at some point in 2027. So again, employers should be thinking now about how to prepare for the collection of this data and how to encourage workforce participation in order to achieve meaningful declaration rates in due course. Next slide, please. Now, finally, we just wanted to remind you about some of the other provisions under the Employment Rights Act, which are not expected to come into force until 2027 or even beyond that, although the government has not yet given any indication as to when. In the interest of time, I'm going to address these briefly. Firstly, the enhanced protection against dismissal for employees on family leave will be introduced. Side by side with this, bereavement leave eligibility will be extended beyond just parental bereavement leave to wider categories of employees. Changes in relation to blacklisting are also expected, which essentially will extend existing protections to cover discrimination by bodies other than employers or employment agencies. There will also be changes to the flexible working regime, in particular that employers will be required to justify any decision to decline flexible work, and we expect consultation on this in due course. 2027 will also see regulations, which Paul mentioned earlier, which regard what will be considered reasonable to determine whether an employer has taken all reasonable steps to prevent sexual harassment. Also, the introduction of the new threshold test for collective consultation will occur at some point next year. Finally, changes relating to 0 hours contract workers and the right to guaranteed hours will also be implemented in 2027 as well. And just to dwell on this final point for a moment, this is yet another potentially significant area for employers with a large number of 0 hours contracts. In summary, the Act stops short of banning 0 hours contracts altogether, but it is designed to give workers greater predictability and greater security over their working patterns. And this is going to occur in 2 main ways. Firstly, there's going to be a new statutory right to guaranteed hours. This means that where a worker is engaged on a 0 hours contract or a low hours contract, and in practice works more hours than are contractually agreed over a particular reference period, the employer will be required to offer the employee a new contract which reflects the hours they've actually been working. The worker will then be entitled to accept or decline that offer. And moving forward, employers will need to keep essentially reassessing working patterns at the end of each reference period and making further offers as and when appropriate. Secondly, the Act will also introduce new rights around shift patterns. Employers will be required to give workers reasonable notice of shifts, including the date, the start and end time, and the number of hours to be worked. And where a shift is cancelled, curtailed, or moved at short notice, the worker will also be entitled to a statutory payment. So that brings us to an end, really, of our gallop through the Employment Rights Act 2025, or ERA 2025, as it's already been coined. And frankly, I think in respect of some of these changes, it really does feel like a new era of employment rights. And with that, I'll pass back to James.
Thank you, Jonathan, and thank you, Paul. A really, really interesting discussion on what's coming in and what's already happened, and a huge amount covered in such a short period of time. So thank you for that. We've had a couple of questions come through, and Paul, one for you to start with. In relation to the new duty to prevent harassment, what key areas should firms be assessing from a risk assessment and governance perspective?
Good question. Well, all sorts of things, really. You should be auditing your workplace culture to find out where these problems are and what staff are reporting, and assessing vulnerabilities. And this might be through surveys or perhaps feedback through the appraisal system, but you need to capture this stuff as an employer so that you can assess risk and do something about it. You should review reporting mechanisms so that they actually work within an organization in relation to harassment claims, and you've got the correct people involved who can do something about it. And down to the granular, that the policy supporting this, for example, on your intranets or however you communicate, are actually there. So links work and this sort of thing. You should also identify high risk scenarios. So they might be all sorts of things. There might be employees who work alone. It might be that there are events where alcohol consumption is expected. And you've got to acknowledge in these situations that there's an increased risk, and you have to assess that risk and decide how you're going to mitigate against it. I saw one question in there related to, for example, third-party harassment and employees going on a work-sponsored event abroad, and they're subject to harassment by third parties. That will still mean you, as a UK employer, are potentially liable if you haven't assessed risks and taken all reasonable steps in relation to that situation to prevent harassment. You should probably look at assessing power imbalances as well. They're a classic dynamic where harassment can occur, and look at it as a risk and decide if there's anything that can be done about that. For example, recognition of people who have the upper hand in a power relationship, and what they can do to mitigate any risks. And I suppose just the third party angle again. Look at your dealings with customers and clients, especially where they're interacting with your employees, and ensure that they're aware of expectations of behavior when they're connecting to your organization. So lots of things, and businesses are going to have very different areas of risk depending on what sector you're in and what your employees are doing, but that's generally how you should approach it.
Thanks, Paul. Really interesting. Jonathan, there's another question that's come in for you. Given the removal of the cap for unfair dismissal claims, particularly for senior executives on significant compensation packages, what practical steps should firms be taking around the bulky considerations and mitigation of evidence?
Thanks, James. That's another really good question. I think, as I mentioned earlier, from the 1st of January, the cap comes off unfair dismissal compensation. So in order to combat this, the best protection to keeping a lid on the potential value of claims, and indeed a lid on the ceiling of potential settlement sums as well, I think will be keeping evidence in relation to 3 issues. So the first is think Polkey, which is where tribunals can reduce compensation based on what would have probably happened if a fair process had been followed. So the question for you is, could you show that even with a perfect process, the same decision would have been reached? And when would it have been reached? Now, my advice would be to make it as easy as possible to see that the same outcome would have occurred and when it would have occurred by writing that down at the time. So writing it down contemporaneously before the termination is carried out, and to keep the documents that prove why. So for example, if it's an underperforming director, and we're talking about performance exit, that could be keeping performance data or KPIs or prior warnings and doing that analysis at the time about why following a protracted performance process would make no difference. So I think that's point 1. Point 2 is think about contribution, which I mentioned earlier. If the employee's own conduct has somehow played a real part in their dismissal, you need clear findings, and again, most importantly, contemporaneous records. So if the conduct in question is misuse of confidential information or it's not disclosing outside interests, explicitly spell that out and spell out that conduct prior to termination. And then third, and probably most important, is mitigation evidence. As you're aware, claimants are required to take reasonable steps to go out into the job market and try to mitigate the loss. They can't just sit on their hands as time goes by and expect the value of their claim to rise. My advice is proactively build your case on remedies at an early stage. Don't just assume it will happen when it comes to a potential trial 2 years down the line. So by that I mean is spend a little bit of time at the time of termination, gathering market data at that time and proof of alternative roles and levels of earnings. Don't rely on assumptions 2 years down the line. So for senior executives, you might even want to consider expert evidence on vacancy data and remuneration benchmarks during that period immediately following dismissal. Specialist evidence, especially in relation to the relevant geography and the relevant sector, would be particularly persuasive. So in summary, James, concentrate on 3 things. It's Polkey, it's contributory conduct, and mitigation evidence. And I think that even in an uncapped world, you can meaningfully limit the risk. And the answer really is the earlier you prepare the evidence, the more you'll be able to contain that financial exposure.
Thanks, Jonathan. Makes a lot of sense. I remember being told off myself by a district judge for not taking contemporaneous notes many years ago in a different career. So contemporaneous notes are clearly super important. I thank you again to Paul and Jonathan for sharing the insights today. It's clear that these reforms are going to have significant implications for many different organisations. If anybody on the webinar today would like to continue the discussion or requires specific advice and would like to speak to Paul or Jonathan, the QR codes are on the screen at the moment. Of course, if anybody on the call would like any support around leadership, compliance, employee relations, or any types of regulatory change programs, or indeed recruitment full stop, then feel free to reach out to me. But thank you to everyone for joining today. I hope you've enjoyed it and it's relevant. Have a great day, and we hope to see you again on the next webinar. Thank you.